Hey guys, I know it's been a while since I last posted a video. Life happens and it will continue to happen, and so I'll always take short breaks where I feel I am unable to juggle both posting Legal 101 and having my regular day job. So, yeah, this week we're in a good space. I'm able to balance. So, yeah, there's gonna be videos throughout the week. Now, today being a Monday, we're talking about employment and labor relations law, and we are borrowing from a judgment that was delivered by Justice Bonani in 2024 this year, and it's pertaining detainment of an employee. Okay, so what do you do as an employer if your employee is found in possession of property belonging to you as an employer? Now, in this case, it was in 2019. This employee had been engaged by the employer in a 3-month fixed-term contract, and one day, as he was leaving the work premises for home, it was evening time, he was found in possession of property belonging to the employer, concealed in a bag. He could not provide the security with satisfactory reasons for having that, which did not belong to him. And so his employers were called on the phone, and the manager said, it's 5 p.m. now, we are not able to come and assess the situation and interrogate this person or find out what's happening. So what you do, detain this man at the premises until tomorrow morning. Now, according to the employee, he was detained in a toilet without food all night long, okay, which obviously is inhumane and degrading treatment. According to the management, they said, apana, we put him in the sentry. Sentry is, you see, on buildings, the entrances of buildings, there's usually like a small room where the watchmen and women sit. That's what a sentry is. So according to the management, they said, apana, we told the security to place him at the sentry. The following day, the management came, interrogated him, apparently forced him to write a confession, never once involving the police. Now, of course, this man then sued and said, I was detained, my freedom of liberty was curtailed by my employer. There was a presumption of guilt when in fact I had not stolen anything. I was detained here all night, no food, in the toilet. It is conduct unbecoming, it's a violation of my human rights. And so the court looked at all the facts and said there was no proof that the management had actually contacted the police, and actually the burden was on the management to find out, to make this report to the police so that they'd have this person picked up and interrogated by the police. In fact, the court said, looking at where you are, within a 10-minute radius, there's a police station. I wonder why you did not think to go and make a formal report at the police so that they can come and pick the suspect. Why would you let somebody stay there throughout the night? The court also said, you said that this employee consented to being held overnight pending investigations, but actually there's no evidence that they consented. And they said, on this issue of food, you are denying that you left this employee there without food, but actually you are not giving us any proof to controvert what they have said. And none of your witnesses were those guards who you actually instructed to detain this person. You're bringing to us people here who are giving us hearsay evidence. You're not bringing the actual people who are on the ground. They'll be able to tell us where this person was actually held, and maybe we'll be able to cross-examine them and see whether they're telling the truth or lying, but you did not actually bring them. So the court said the employee was arbitrarily denied of his freedom. He was subjected to psychological torture and undignified treatment, contrary to Article 29 of the Constitution of Kenya. And being that this was a petition aimed at compensating the victim, deterring future violators, and benefiting the public in general, the employee was awarded 1.5 million in vindication for violation of his constitutional rights. Now, you might want to ask yourself as an employer, somebody has stolen from me. How do I go about making sure they are held accountable? I mean, me, I just held them there. It was 5 p.m. Nobody was there and I couldn't let them go. Tomorrow, they probably wouldn't come back and I'd have lost my property. But this is what you do. You know, a person who is arrested for theft or for a cognizable offense. A cognizable offense is one where the police don't need a warrant of arrest. That person is going to be arraigned. It's going to be charged and arraigned in court. Now, if within 14 days they are not released on bail or bond or set free in other lawful manner, the employer has a right to terminate the employment without notice or with less notice than that which the employee is entitled, provided the employment is terminated in accordance with fair procedure, meaning the disciplinary hearing, where the employee will be given an opportunity to come and explain themselves. They'll be asked, okay, these are the allegations. Can you talk about whether or not they are true? There's going to be an investigation. There's going to be a proper hearing. Okay? And if the employer still feels that they do not want this person around them, then issue them with all the payments, all the terminal dues, and set them free. But you cannot detain them, force them into a confession, never involve the police, just because they steal from you, because in the end you will find yourself in such a situation. And in this case, the court actually awarded this person 1.5 million. Okay, and yet there could have been a theft. Okay, but look at what they're undergoing. 1.5 million is a lot of money when you feel you're the one who has been wrong. So this is just to assist you remain compliant as an employer. And yeah, that marks the end of today's Legal on One. It's great to be back. See you tomorrow for tax law. Bye.